We continue with the jury trial. State of Wisconsin plaintiff versus Stephen Avery, defendant. Jury trial, Voir dire, day 3, February 7th, 2007. The court. At this time, the court calls State of Wisconsin versus Stephen Avery, case number 05-CF381. We're here this morning to begin the third day of individual voir dire. Will the parties state their appearances for the record, please? Attorney Fallon. Good morning, Your Honor. May it please the court? The state appears by Assistant Attorney General Tom Fallon and Special Prosecutor, along with Special Prosecutor Ken Kraft. Attorney Buting. Stephen Avery is here in person. Jerome Buting represents him, as does Dean Strang. The court. All right. There's a few matters we have to clear up from yesterday before we call out the first juror. First, at this time, I had a chance to look at the jury questionnaires. There were 3 jurors yesterday that the parties jointly recommended be stricken for cause, and I believe the clerk has the names and numbers. The clerk. It was juror number 44, Kevin Kayenberg, juror number 37, Mary Lukes, and juror number 39, Betsy Rodick. The court. Does that square with the parties' recollection? Attorney Strang, yes. Attorney Fallon, yes, that's correct, Judge. The court. All right. I have reviewed the questionnaires in those cases, and I agree with the parties' recommendations. Those 3 jurors will be stricken for cause. I also indicated to the parties before we began today that, well, first of all, at the outset, the court had indicated it wished to place a 15-minute limit on each party for individual voir dire of the jurors. The parties were both heard on the record and felt that time would be too short. I indicated, I believe, that I would monitor the situation and somewhat loosely apply the limit. Having heard the voir dire of the jurors who have been questioned to date, the court believes that if unnecessary visiting with the juror questions are eliminated and repetitive questions are eliminated, I'm not sure that I have heard any juror for which 20 minutes per side would not have been sufficient. So I'm going to impose a 20-minute limit on each side for questioning any particular juror. I do have a timer here that I will be using. The way it's set up, and I don't think I can overrule it, but perhaps it's helpful. It gives a short little beep at every 5-minute interval. So the beep you hear today will not be the laptops of the media, but will be coming from the timer. And when the last one goes off, if the parties wish, I will give you just a brief warning that you have got 5 minutes left. I won't give it if the parties don't wish me to, but if you find it of assistance, I will, counsel. Attorney Fallon. I understand the court's reasoning and will do our best to abide by the time limit and see how it goes. But as I think about the last couple of days, quite frankly, notwithstanding media perception, I don't think we're doing all that badly or going all that slowly. Actually, it feels almost about right, a little tedious yesterday, but our concern is having adequate time to explore the issues. And like I said, the state will do its best to abide by the 20-minute time limit. But as I think about it, I don't think on average we've spent more than 40 to 45 minutes on average per juror. And as the court is aware, the parties have agreed to strike for cause somewhere in the vicinity of 50 jurors, thereby saving a great deal of time. But in terms of right now, we'll see how it goes, and we may renew our request for extended time depending on how it goes. The court. Mr. Strang. Attorney Strang. I do object to the time limit for a number of reasons, acknowledging that the court has broad discretion in controlling voir dire and superintending the process of jury selection. But the overriding concern here, as the court itself acknowledges, and I know the court understands this, is that we're trying a case in which a man, the rest of his life hangs in the balance. And for the other side of the courtroom, in which the public has an enormous and legitimate interest, and one family in particular has a very deep personal interest, picking 16 fair jurors who come to this case after 15 months of publicity that has been unusual in its pervasiveness and its consistency, without ascribing or characterizing it further, There's been an enormous amount of publicity in this case, and it's not at all unreasonable here for the parties to explore in voir dire well beyond the basis for cause in striking a juror, but explore further the information that will allow each side intelligently to exercise the few preemptory strikes the Wisconsin law allows each side. In 2 long days of voir dire, I and Mr. Buting collectively have made exactly one objection to a question posed by the state, and as this court knows, I'm not shy about making objections, and neither is Mr. Buting. So we made one objection because we thought that there was one objectionable question in 2 days. We have not posed a single question between the two of us that we thought objectionable. We don't intend discourtesy to the court, and we don't intend to do improper things. The court has made several, although not a great number of objections to our questions, some of which the court has sustained, and some of which it has overruled. But in the main, I expect that counsel at the next table would join me in agreeing that neither side has wandered off into inappropriate material. Now, when the court times each side on each juror and a little chime is going off, we're chilling not just the lawyers, but more importantly, the person who is trying to open up in an alien environment and give us some information that's very personal to a bunch of strangers about themselves, about their attitudes, and about their deepest held convictions. And with the chime going off every 5 minutes, I don't expect the same level of candor from jurors who are already uncomfortable and in an alien environment, surrounded by strangers who do very different things with their working lives than they do. So if the court is of a mind to set some time limits, and I certainly understand, I share the desire to be out of here before 6 or 6:30 at night because of all the work we have to do after we leave court. But if the court was going to do that, I would ask the court, instead, to set something like a 3.5-hour day limit on each side, and let us apportion that time as we will, because it is one of the other problems with the 20-minute limit per side per juror is that not all potential jurors are created equal. Some of them can be accepted, or for that matter excused, in 5 or 10 minutes total. Some of them are well worth an hour's total exploration. And if that happens to be 40 minutes by the state and 20 minutes by the defense on one juror, and 30 minutes by each side on the next, that's just the way it is, in my view. Each one of these people is individual and presents individual issues for the respective sides in this lawsuit. So we're in an area of the court's discretion. I understand and respect that. I'm asking the court to exercise it a little bit differently in hope here of fleshing out not just cause to excuse a juror, but all the information we reasonably can hope to have so that we might exercise intelligently our peremptory strikes when there's everything at stake at the defense table and enormous legitimate interests at stake at the state's table. The court. All right. I want to, in light of those comments, I want to make a few additional ones of my own to make sure that the court's ruling here is not misconstrued. First of all, I will state for the record that the court is very appreciative of the efforts that counsel for both sides in this case have made to thoroughly review the written questionnaires that were used and agree to strike before individual voir dire those jurors whose answers demonstrate that they would have great difficulty meeting the qualifications of a jury in this case. I'm not imposing the time limit as a punishment for the conduct of the parties. I believe that the attorneys have been very responsible. When it comes to whether questions on voir dire are objectionable, it's often more of an art than a science. It's not so much that a particular question is or is not objectionable, and certainly in this case, the court recognizes that a legitimate area of inquiry from both parties on voir dire is the extent to which jurors have been exposed to pretrial publicity and the effect that publicity might have on their actions as a juror. And if it appears that any particular juror has been so exposed that 20 minutes is simply not enough. I'm not saying the court would not entertain a request for longer time. However, there are some other questions that have been asked, many of which is, taking the first 5 minutes to ask the jurors something about their background, whether it be employment or hobbies or whatever, that isn't particularly germane to the qualifications of the juror. And I'm looking with the time limit to get the parties past that and into the meat of voir dire a little bit quicker. If I felt that by imposing a 20-minute limit, either party would be prejudiced to the point that they couldn't get the information that they need to evaluate jurors, I wouldn't set the time limit. I'm setting it based on my observations of what's happened so far. And while it's not the primary consideration, I'm also trying to give a little consideration to the jurors who are waiting to be called out there. So with that background, before we begin then, there was also a question, and I will stick the timer on the floor in order to muffle, to the extent possible, the noise it makes. I think you'll find it's not as loud as what we were hearing from some of the laptops yesterday. There was one other remaining issue from yesterday relating to the juror, Nathan Klein, and the answers he gave to questions relating to his exposure to radio at work and the fact that he heard something within the last week, I believe it was on Monday, about blood vial evidence. I have reviewed, and have the parties received this page and a half? Attorney Strang, no. Attorney Fallon, no. The court, why don't you come up and take a look at it now? My review of the answers that he gave to the questions was consistent with my recollection at the time. That is, he indicated he's at work. The radio is always on at work. He did hear news last Monday about the blood vial and the state's request to test it. He was candid in describing that he had heard that, although he indicated he tries to avoid listening to the radio while at work, but did admit that he heard this particular story. He indicated that he thought that the planting of the blood vial evidence was a possible defense in this case. He was hoping that there would be some results from the tests, but if there weren't, he said that then he would look at something else. First of all, I would note, I believe he, based on the answers he gave, he has attempted to comply with the court order as best he can. Obviously, should he be selected as a juror in this case, he won't have to worry about being exposed to the radio at work, because he won't be at work. Secondly, I would note that, in the scheme of things, the danger that pretrial publicity would prejudice a juror in this case is far greater with respect, for example, to what they heard or remember about Mr. Dassey's statements, which may or may not come in at trial. I think that this is not such a major item that it could be expected to have a dominant effect or foreclose him from indicating, as he did, that he could put his exposure to pretrial publicity behind him and become a fair juror and base his decision only on the evidence introduced at trial. So I don't believe there is a basis for excusing Mr. Klein, and he will remain as part of the jury panel in this case. Attorney Strang, just a couple of things to make the record clear on that, Your Honor. The transcript excerpt the court invited us to look at when we approached the sidebar were pages 139 and 140 of the February 6, 2007 transcript of proceedings. And I think the ruling concerning scientific testing to which the juror, or Mr. Klein, the prospective juror, referred concerned the court's February 2, 2007 ruling on allowing testing, although the court already has ruled or previously has ruled that the results of such tests at present are inadmissible and may not, and the possibility of doing EDTA testing may not be mentioned by either side. The court. Mr. Fallon, is that a fair summary from your perspective? Attorney Fallon. Not quite. It is with respect to a ruling the court issued, I believe, in January, relative to the presence or absence of EDTA. However, it does not encompass other potential scientific testing. Secondly, if not, and it hasn't been directly or filed or stated in court, but that I think decision is subject to review and a motion to reconsider, since that determination was held without evidentiary hearing, without facts, without argument, and was based upon, to my recollection and knowledge, an unpublished federal district court opinion out of California dealing with post-conviction motion. So with those caveats, I accept counsel's representation. But the state's position is that the ruling relative to Juror Klein is appropriate. The court. All right, well, what the court did rule is the court was going to allow, and has allowed, the state to conduct tests on the blood vial from the clerk's office. I have also provided that sufficient sample be set aside to allow the defense to do the same. And I specifically reserved ruling on the admissibility of any test results should any test results be obtained. Otherwise, I believe Mr. Strang's summary of things is accurate. Attorney Strang. Okay, am I correct that the current state of rulings of the law of the case is that EDTA testing is not admissible, and as things stand, that was the court's January something order, and that neither side may mention the possibility of doing EDTA testing to the jury? The court. Well, those are two different things. First of all, the court did not rule that EDTA test results are not admissible. The court ruled, in essence, if I can summarize my ruling, that there have not been proven to be such reliability that they justified an adjournment of the trial in this case to await the results of such testing. And I did that based on the information that the parties provided me, which both parties represented was the best information on the state-of-the-art of such testing, namely the California decision to which Mr. Fallon referred. I do not believe I was asked to rule on the admissibility of EDTA test results. I have not done so at this time. There are no EDTA test results. As to whether either party could mention them in an opening statement or otherwise, I think the rule would be the same as it is with other evidence. I don't recall being asked to make any such ruling, nor do I recall that I made such a ruling. Attorney Strang. We probably both should go back and look at the written ruling then, because maybe my recollection is faulty. The court. Okay. Attorney Fallon. Your Honor, if I may make one comment on the voir dire process, just to clear up the record and to make a point. We accept the court's ruling that I would like the record to reflect that what many perceive as 5 minutes of chit-chat questions by the state, or the defense for that matter, as they begin their voir dire process, while we agree that it does not go directly to the potential of a strike for cause, it has two very valid purposes. One, information obtained during that introductory questioning is quite valuable in determining how one would exercise their peremptory challenges. And secondly, picking up on a point that Mr. Strang made earlier, it's incredibly difficult to start a conversation with somebody in saying, well, good morning, sir. I understand you're a victim of a crime, and how do you feel about that? It seems to me that there ought to be at least some time for a person to walk into a courtroom such as this, with all these people looking at them, where they are clearly the fish in the bowl, and make some human effort to relax them and engage them so that they can honestly answer the questions. So that's the reason for that question, for those type of questions. And I just want to record the record to be clear about it. It's not like we're wasting time or trying to be buddy-buddy with jurors. The court. Well, that's one of the reasons I'm setting a time limit rather than objecting to when the court may believe that the number of visiting questions is excessive. I think the best way to police it is to simply set a time limit. Attorney Strang. Could I have a minute to make a motion before we move on? The court. Yes. Attorney Strang. Only in part, but only in part, because of the 20-minute time limitation the court has imposed this morning, I'm going to move to strike prospectively here every juror who's heard a news conference about Brendan Dassey or Stephen Avery from March 2 back. I mean, nothing I'm not worried about anything after March 2, but from March 2 back, if they've heard those news conferences and remember them. For all of the reasons I have argued in this case, from the motion for sanctions that I filed last spring or summer up through the motion to dismiss a couple of the counts and the request for curative steps by the court. And in light of the limitations now on the time to explore and possibly rehabilitate someone who has got that kind of gripping information about Mr. Dassey or Mr. Avery, I'm just going to move to strike for cause all of them who saw that, those news conferences through March 2, or any of them. I realize that we've got a number of people in the qualified group of 16 who did see that, but there comes a point where there's a tipping point, and the court so far has not taken the curative steps that we requested. This is an alternative curative measure that I'm suggesting, and again, the urgency for it went up a bit this morning with the time limitations on voir dire. The court. Mr. Fallon, Attorney Fallon. Well, I take it, counsel, you're asking for those who saw conferences from November 9th through March 2nd? Is that the time frame, or is it from March 2nd to now? Attorney Strang. No. November 5th to March, Attorney Fallon. November, Attorney Strang. 2005 through March 2, 2006. I'm not worried about anything after that, and I'm not going back and moving to strike any of the 16 we have already qualified. Attorney Fallon. I guess my take on that, Judge, is for obvious reasons we would object to that. First and foremost, the first thing that comes to my mind is that that's a premature and it's an insufficient record upon which to make a class action objection based on perceived or anticipated bias. Secondly, it seems to me that much of those concerns have already been addressed as best we could by this court and the steps that we've taken in this case since May. And those include an adjournment of the trial from beginning of September to, then, the middle of October until now. So it is 15 months since the date of the crime and 11 months since any news conference at all from the state relative to the events of the crime. Secondly, we have engaged in a jury questionnaire process, which I think was directly aimed at fleshing out those who have too much of a bias, or at least think that they have too much of a bias based on the pretrial publicity. And we have expected a fair process, and we have expected that we would have to exclude a large number of jurors. In fact, we have 50 or so more. Not all of them for subjective bias, some for economic hardship, but I think the process that we are engaged in is working. And third, I guess I would note that it is the defendant's constitutional right. He had the opportunity to waive that right and ask for a jury from another county, but instead wanted to, for lack of a better term, take his chances with the jury of his peers here in Manitowoc. That is his right. That is his choice. As a result, we're obviously going to do a lot more sifting and winnowing from the prospective jurors, those who do not have such a bias, to participate in this case. So I think we have to take, as counsel eloquently argued about an hour ago, each juror is different. Each one takes more time. Each one has a different set of issues, a different set of perspectives, interests, and biases which need to be explored. And I don't think that we can sit here and just simply say, because you have seen 2 news conferences, you're out. I think that's unfair to them. It's unfair to the state, and quite frankly, oddly enough, I think it's unfair to Mr. Avery. So we would oppose the request. The court. All right, well, the court is going to deny the motion to, on a wholesale basis, disqualify any juror who may have seen these news conferences. The court believes that while a juror who has seen the news conferences certainly raises some concerns about the juror's ability to be fair and impartial if selected in this case, the questioning to date has proved that there are some people who are capable of doing that, and both parties have agreed about that. There are a number of mitigating factors in terms of causing prejudice to the jurors. The news conference took place nearly a year ago. A number of the jurors were aware that since the initial news conference, Mr. Dassey has recanted at least parts of his earlier statements. In some cases, the jurors have been exposed to information about blood being planted, and the jurors are aware of defenses as well as the initial reports from the state. Finally, there are a number of jurors who are capable of setting aside that information. They have been asked questions by the defense to suggest that there may be, if the Dassey confession evidence comes in, there may be witnesses who explain why. Even a confession, if it was made, may not be true. The court has allowed a variety of questions, and I think that it's just simply unfair to say that any juror who saw the news conferences cannot possibly be fair and impartial. A number of them have been stricken, but some of them weren't. And I think the process to this point has worked fairly, and I don't see a reason to believe it won't continue to do so. Let's see. I think the next juror we have up is Mr. Mahler. The clerk: yes. Attorney Fallon: yes. The court: very well. Mr. Mahler, if you can raise your right hand, the clerk will administer the oath to you. Juror sworn. Voir dire examination by Attorney Fallon. Good morning. Is it Mahler or Mahler? It's Mahler. Mahler: good morning, sir. My name is Tom Fallon. I'm an Assistant Attorney General with the Wisconsin Department of Justice. I'm one of the prosecutors in this case. To my immediate left is Mr. Ken Kratz, Calumet County District Attorney and lead Special Prosecutor. Thanks for coming in this morning, and thank you for your patience. Both sides have some questions we would like to ask you regarding some of the information contained in your questionnaire, and perhaps cover a few areas not covered by the questionnaire. I think a matter of great interest, and you might detect a bit of envy on our part, but I note from your questionnaire that you managed to be retired at what appears to be a rather young age. What did you do before retiring? I was in the cleaning business, and I have been a musician as a hobby. And how long were you in the cleaning business? 10 years. 10 years. 12 years. Now, you were an employee, or did you own or run a business? I worked with the gentleman who owned the business for about 8 years, and then he was dying of stomach cancer, and I took over the business. My wife purchased the business from him. Okay, all right. And do you still keep your hand in that business? Yeah, something to keep busy. I work like 6 hours a week. All right. On my time? Okay, tell me about the music business. How long have you been involved in music? 32 years. All right. Over 23 years, I'm sorry. 23 years? 23 years, right. All right. Since I was 16. And is it a business that's more of a hobby, or do you actually use it to earn income? Well, I do earn income from it. All right. Not very much. I mean, if you weigh out what you spend on the equipment and all the other stuff, I don't make any money at it. All right. What type of music are you involved with? A variety. All right. I do variety. I'm the lead singer and bass player. Used to be a guitar player. Lead singer, and you play bass and lead guitar? Rhythm guitar. Rhythm. Okay, this group you are involved with. How many are involved in that? It was 5. Now it's just me, my wife, and lead guitar player, until we can find a drummer. And how many gigs a month do you normally do? It varies. Okay, all right. I see also from your hobbies that you like computers? Yes, sir. What particular tasks, or how do you use the computer? For what purpose? My mixing down music, recording music, writing out lyrics, typing out lyrics, that kind of stuff. Do you use the computer at all for information purposes or to get news? No, I don't. All right. In that regard, I would like to talk a little bit about your familiarity or lack thereof of media coverage with respect to this case. Let me first ask you, you indicated you get your news from 3 sources: radio, television, and newspaper? Right. Of those three, where would you say you get the lion's share of your news information? Usually the Sheboygan Press. Sheboygan Press? Yeah. All right. So you are a regular reader of that? Yeah, pretty much so. How about television and radio? It's not much into television because there's nothing really on that I care to see. All right. And radio, I listen to the music, that's about it. Okay, so you don't listen to any news shows or talk radio? It's just for the music? No, I don't really care for it. I'm sorry. I don't really care for the news? All right. Just haven't shown an interest in it? No, I'm more into music and stuff like that. All right. If you could do us a favor and maybe lean forward a little bit and talk into that microphone. I can't move the chair, so I understand it's a little difficult, but all right. We do need to hear your responses. Thanks. Yes, sir. In terms of the media coverage attended to this case, have you seen any of the newscasts or media coverage of this case at all? No. At the beginning I remember my wife saying something about that Teresa was missing. I remember that part. And then she told me something later about some fire pit or something, but that's about all I know. All right. Excuse me, you haven't followed any of the newscasts then? Or any of the information that's been developed other than the original breaking of the story? Right. All right. You have listened or heard nothing on the radio recently or nothing on the television recently? No, I haven't really listened to the radio at all. All right. And from the information you provided in your questionnaire, you indicated you haven't formed any opinions based on the small amount of information you currently have? No, I have no opinion. All right. 'Cause I don't know any of the evidence or anything. Okay, well then, let me just conclude this aspect of the questioning with this question. If you were selected as a juror in this case, do you think that you would be able to decide the guilt or innocence of Mr. Avery solely on what you hear in the courtroom? In other words, the evidence which is presented and on no other source. That's correct. All right. You have no problem with that? No. All right. Since you're into music and those types of endeavors, I thought I would ask, do you watch old movies or are you a movie guy? I like the old Jerry Lewis, Dean Martin movies. All right. Do you ever watch any documentaries, anything on law enforcement or anything like that? I think one of my favorite shows I watched on TV was Law and Order, but that's all right. Probably the only thing that I see that was worth watching on television. Okay, did you ever see a documentary called The Thin Blue Line? I've heard of the name, but I have never. You've never seen it? No. Okay. The next area of inquiry that I have for you is any encounters that you or your family may or may not have had with the local police department or the sheriff's department. Have you yourself had any reason to call upon them for services or had your interaction with them? Not at all. All right. Any other members of your family have any encounters with the police or law enforcement? My stepson, I mean. Okay. This was about a year ago. He wrote out prescriptions for himself, which is kind of okay and dumb on his part. And he didn't have any, and he shouldn't have been doing that, right? Right. All right. Was he arrested for that? Yes, he was. Okay. Based on your experience for that, or with that, did you have any direct contact with the police or the sheriff's department in that incident? No, since he's not my son, my wife. Okay. I stay out of it. Sure. It's better if I stay out of it. All right, well, let me ask you this then. I imagine you might have had at least some discussion of that happening with your wife. No? Okay. She doesn't like me getting involved in the family business. It's like, get out of here, stay out. All right. It's none of your business. So you didn't have any discussions as to the appropriateness of the law enforcement activity or involvement in that? Nope. Okay. So you don't have any particular opinion regarding how the case was handled or anything like that? No? I don't know anything about it. Okay, fair enough. In terms of how you go about approaching solving a problem, or even in your interacting with other people, in discussing and formulating opinions, would you consider yourself a detail-oriented type of guy, or are you more of a big picture perspective, bottom line approach to things? I try to piece together things. Okay, so do I interpret that to mean you do kind of look at the details? Right, I'm articulate. Okay. When it comes to things like that. Attorney Buting. I'm sorry, I couldn't hear that. Answer. I'm articulate when it comes to, like my music, picking things apart and trying to put it all together. All right, so the nature of your interest, your hobby in music, makes you tend to be more of a detail-oriented approach in terms of putting together music or scoring it or writing it. Right, to get it to where it's just so the words fit the music? Right. Okay. And the feeling is there and everything comes together. Okay, all right. Attorney Fallon. That's all I have. The court. Mr. Buting? Attorney Buting. Thank you, Judge. Voir dire, examination by Attorney Buting. Good morning. Good morning. My name is Jerome Buting. This is Dean Strang, another Jerry. Dean and Jerry combination, but not like the movies that you've seen. We represent Stephen Avery, and I want to follow up on a few things that Mr. Fallon has asked you, but also get into some different issues that maybe will come up and you're going to have to consider, all right? Okay. First, just in more general background, your name. It may be just a coincidence, but are you related in any way to the Peter Mahler that has a office cleaning business in the Milwaukee area? No, sir. Okay, just a coincidence, I guess. You list 2 female children at age 17. Are those twins, or are they from different marriages? My daughter was from my first marriage, one of them, and she's living with her mother. And the other one is living with us, and she's my stepdaughter. I see, okay. I thought maybe she was a stepdaughter, but you didn't mention your stepson in here, so maybe that's... Yeah, he's like 23 or something like that. So he's on his own? Correct. Okay, and your wife is retired also? Yes. Well, when you say retired, it wasn't clear to me. You still have the cleaning business? I do it to keep busy. Okay. My wife has a trust fund out of Milwaukee. Your wife has what? A trust fund out of Milwaukee. She gets dividends every month. Oh, I see. Okay. And that's your primary source of income, and you don't have to worry so much about the cleaning business? Correct. Okay, but is your wife your current wife? How long have you been married to your current wife? 10 years. Okay. And she's in the band too? Right. What does she do? She plays the piano. Okay, and you play around Manitowoc County, Sheboygan. What's your area? Manitowoc, Sheboygan, Plymouth, Tri-County pretty much. Okay, and you mentioned you have actually sung the national anthem at Road America? Right, for all the races I do. Okay, that's something you've done for quite a while. The past 7 years. Well, okay. Are you interested in racing too, or? Yeah, I said if my voice ever went, I would get into racing. So, do you work on cars yourself? No, I just have a love for the racing thing. So you have a love for the racing, but you're not really mechanically inclined, or? No, I never really got totally into it. I just like watching. Okay, especially the motorcycle races. You would like to be the driver and not the mechanic? Right. Okay, now, in terms of knowledge that you gained about this case, it sounds like your wife is really the one that was the source of any information? Yeah, I guess she's been keeping up on it, watching the news on it. Okay, so she does. She shows an interest in it, right? And she likes to talk with you about it on occasion, apparently, right? Right. Sometimes it's hard to remember when someone says, tell us what it is you remember hearing. And sometimes you don't. Doesn't come to mind, certain things. But you actually really did hear them. You just don't recall at this moment. So I just want to maybe explore that a little bit, okay? Okay. For instance, Brendan Dassey, have you heard of him? I have never, no. Have you heard anything about a nephew of Mr. Avery? I have heard about the nephew, but I don't remember names or anything. Didn't connect the name. Okay. What have you heard about the nephew as has been reported? I don't recall. Okay. Do you recall anything either you heard on the news or that you talked about with your wife about the nephew that involved his alleged confession or admission to certain things? Nope. She never discussed anything about the nephew or anything about his later recanting of those confessions, and nope, denying it. I didn't hear anything about that. Okay, did you, in talking with your wife, did you ever hear anything about, what it is that Mr. Avery was supposed to have done here? I remember that Teresa was missing, and that's about all I remember of it. And supposedly he was accused of her disappearance, but that's about what I know. Okay, and when you say Teresa, did you know her at all? No, just my wife and some of the things I've seen in the paper. What kind of things do you recall having seen about her or learned about her? I know she was from, I don't even remember where she lived. Do you know what she did? How and why she was missing or involved in this at all? I have no clue. Okay, other than your stepson, which you probably wisely stayed out of, have you ever had any exposure to the police yourself? 12 years ago, a Manitowoc sheriff picked me up because of a computer mistake in Sheboygan with child support. Okay, said I was behind on my child support, but I wasn't. And when you say picked you up, did they actually take you down and book you and all that? Yeah, and brought me to Manitowoc County Jail. And how long did you sit in jail? I think, in Manitowoc for one day, and then I was transferred to Sheboygan until Monday morning, because they picked me up on a Friday, which was kind of weird. Then I sat for the weekend because there was nothing they could do. So Monday morning, my wife came in, paid a little bit on my child support, just to get me out and take care of that situation. But, I never missed a payment, but it was a computer glitch that, happened. So you had to spend a whole weekend in jail for something really that was just a mistake? You didn't write? Wasn't your fault? That is correct. Well, how'd you feel about the system when that happened? I mean, mistakes happen, There was nothing I could do about it, so I accepted it. Okay, what do you know about Mr. Avery's background? I know he owned some kind of business out here somewhere. Do you know anything about all the information about he was wrongly imprisoned for many years and was later exonerated when DNA tests proved he didn't do the crime? Yeah, I seen one news report when he got out, out of jail the first time. Yeah, I have seen that many times. He looks quite a bit different today, doesn't he? Yeah, a little shorter in person. That beard that he had was quite a bit different too, but in that environment you have to adjust, I suppose. Did you also read anything or hear anything about how he had a lawsuit against Manitowoc County? I might have heard bits and pieces about it, but I don't know much about it. Because of that whole experience, do you have any opinion about whether or not that was a good idea or a bad thing for him to try and sue because of his wrongful conviction? I don't have any opinion on that. Okay. Other than that one encounter that was a Manitowoc County Sheriff, you said? That's correct. Any other contacts with the police, even when you were growing up as a teenager or, out after curfew, any kind of, not arrest, but times when you have encountered the police? Yeah, speeding tickets, things like that. Do you think that the police officers, because they take an oath, get a badge, that they're supposed to serve and protect, that somehow if they come into court and testify that they're always going to tell the truth? I think they would. Well, you think they would, or you'd hope they would? Well, as their, oath, if they took the oath, I feel they should. Okay, that's fine. But do you think that simply because of that, because of their position, and, we're taught to respect police officers, of course, that's correct, that if you heard testimony from them, that you might give that greater weight and think that they're more reliable and trustworthy than other ordinary citizens you may hear from? Cell phone rang. No? Okay, that distracted me. Okay. Could you repeat the question? Sure, I'm sorry about that. Do you think that because police are police, that if they come into court and testify, that what they say, that we'll look at that as being more reliable and more trustworthy than maybe you would something that you hear from the witness stand that comes from an ordinary citizen? No, I don't, because the police are just telling their side of the story, just like all the other witnesses. And that they're human too, right? That's correct. And do you think it's possible then that police may also be mistaken about things? Well, just because it's coming from an officer doesn't mean it's the facts and totally the facts on the case. Okay. Do you think it's possible that police get, personally involved in a case where they are invested and they really care about the outcome? That they're not just just the facts, ma'am, that kind of thing? Well, I think they're just, like I said, they're just telling what they discovered from the case, and it has to all be weighed out. If you heard evidence that might indicate that police officers in this case maybe were a little more personally involved in things related to Mr. Avery, would you be able to consider whether that kind of involvement or motive might affect what they're saying on the witness stand? What do you mean by personally involved? Well, I don't want to get into all the evidence here. I mean, if you're selected, you'll hear some of it, but that's correct. But the judge will give you an instruction that police officers are to be judged as witnesses just the same as any other witness. That is, that they have no special aura about them that makes them more honest or trustworthy than any other witness. You have to judge their demeanor, what they say, what the facts are, if there's any corroboration or conflicting information. And what I want to understand is if you can do that. Yes. And can you do it even if it means more than just that maybe the police are shading or even lying about something? Can you do that and consider whether or not the police crossed the line in this case and went way beyond what simple investigating is? Well, I judge their evidence just as I would any other witness. The same, They don't have, they're just telling what they know, and the other people are testifying are telling what they know. And there's no difference between an officer and somebody else who's testifying. All right, well, you say they're just telling what they know, but you understand that sometimes witnesses come into court and even under oath that they tell lies? Right, I do. And if you're selected on this jury, you're going to have to make those kind of judgments and judgment calls as to whether a person is really telling the truth or not. Yes, I understand that. Okay, and you can do that for police officers just as the same as others? That's correct. Now, you have a lot of, well, I don't know if you have or not. Did you have musical training or did you kind of teach yourself? I took half a year of lessons and then I got tired of lessons, so I learned on my own and pretty much play by ear. I mean, I know the chords and stuff, but I play by ear. Did you ever take any music theory or learn about any music theory? No. Okay, so in terms of your knowledge of science, do you have any particular background on that or mathematics? No. Well, you may hear some scientific evidence in this case that will come from expert witnesses. And will you be able to listen to their testimony and judge what they say with the same kind of standard as any other witness? Yes. In other words, just because they are professionals, are experts in their field, what they say may or may not be completely accurate. You have to listen to all of what they say. Right. Okay, let me go back for just 1 minute. In terms of what you have heard, maybe from your wife or just picked up, have you heard anything at all about a blood vial? No, I haven't heard anything about that. Nothing about a blood vial? No? Okay, now, you like to, well, let me ask you this. One of the questions talked about a defendant's right not to testify. And I think you understood that in your questionnaire, at least you answered yes, you could follow that. Right. But do you think that if you didn't hear directly from Mr. Avery testifying at this trial, that would be a problem for you? Not at all. You wouldn't be concerned about why he didn't testify? Why haven't I heard his side? No. Why not? Because, I would listen to everybody's input on what they had to say about the case, and I would make my decision on that. Well, on the other hand, if he did take the witness stand and testify, would you think that, I'm not going to really believe much of what he says because he's the defendant in this case. He's got everything at stake. No, I would listen to his side of the story also. You could treat him the same as any other witness, you're saying? That's correct. So, either way, you're not going to hold it against him or us. His attorneys, obviously, will be talking with him about that decision. You'll be able to make sure that doesn't affect your decision in the case? That's correct, either way. And if at the end of this case you believe that a crime was committed, a very serious crime was committed, but you have a reasonable doubt whether Mr. Avery did the crime, will you be able to return a verdict of not guilty even if he or we are unable to show who is, in fact, the guilty party? I don't understand the question. Well, if you hear the evidence and you decide that yes, in fact, a very serious crime, a murder, occurred here, it's maybe human nature to think, well, if Mr. Avery didn't do it, then who did, right? I mean, can you see that? Yeah, I can understand that. But what you have to understand is that the defense doesn't have a burden of proof. And that what I want to know is whether you are going to be thinking, hey, somebody did this and we've got to convict somebody of this crime. And if it's not Avery, he hasn't shown us who it is, who did it, who did do it. So we're just going to go ahead and find him guilty? No, I wouldn't. Why not? Because it would be wrong. Okay, so you really will look at the state's case to see whether the state has proven to you, beyond a reasonable doubt, that Mr. Avery is the guilty party? That's correct. I will look at both sides. And even if coming out of that you say, well, this is really sad. I wish somebody did this. I know somebody did this, and the defense hasn't proven to me who did, but the state also hasn't proven beyond a reasonable doubt that Mr. Avery did. You'll be able to return a not guilty verdict? That's correct. Okay. Attorney Beating. Thank you, sir. The court. All right, Mr. Mahler, the clerk will escort you from the courtroom at this time. Wherein the juror was excused. The court. Any motion from either party? Attorney Fallon. None from the state? Attorney Beating. No, Judge. The court. Mr. Beating, you must have good timing in your head. You concluded exactly on. Attorney Beating. I heard that, and I thought, the court. You beat the clock, though. Attorney Beating. I didn't know if that was the extra 5 minutes over or not.